All right. The Charlie Kirk trial, the Tyler Robinson trial, is still in the mix. We're still in the process. We should be hearing back from the judge, Graft, I believe it is. Don't quote me on that. I think it's September 1st. We're supposed to hear back, I believe, on whether or not the trial is going to go forward or they're going to finish up their arguments on soon enough. So Melba Pierce, who is a fantastic legal mind out here in LawTube, she was speaking about the Tyler Robinson trial and some of the reasons why they wanted to get the death penalty off of the get some of those aggravating circumstances off. It was really interesting, some of the arguments that they were making, because I didn't realize that his attorneys were making some arguments. One of the arguments is that he was too good of a shot. He was too good of a shot, therefore nobody else was in jeopardy because he shot at the target that he was going to hit. Nobody else was going to needed to worry. That's crazy. So let me pull this in. I had never heard this. So shout out to Melba Pierce, the resident legal diva. I will tell you this, though, Pearson. I will tell you, she does use bird hands every now and then. She uses her hands quite a bit to speak, but she's an excellent, excellent content creator, and she knows what she's talking about. So check this out, y'all. Wait, hold on. What are we doing here, Jason? Get it together.
Man accused of killing Charlie Kirk is trying to take the death penalty off the table, and his attorney's argument is one of the strangest but solid arguments you will ever hear in a capital case. So what's that argument? That Tyler Robinson was too good a shot to be a death penalty defendant. I'm not even remotely playing, so let me break this down for you. Hi, I'm Melba Pearson, also known as the Resident Legal Diva, and this is The Breakdown. Make sure to like, comment, and subscribe to Legal AF for all things at the intersection of law and politics, and be sure to follow me at Resident Legal Diva on YouTube, Substack, and socials where I do deeper dives into these issues. So, reminder of the state of play. Tyler Robinson is charged with aggravated murder in the killing of Charlie Kirk at the Utah Valley University in September of 2025. As you may remember, Tyler Robinson allegedly shot him from a rooftop about 200 yards away in front of a huge crowd, right? Because remember, this was a huge rally. He's currently being held without bail. Prosecutors charged him with aggravated murder plus obstruction for hiding the weapon and all of that afterwards, and they're seeking the death penalty. And Tyler Robinson has not yet entered a plea. We've had the preliminary hearing, and we were waiting to see what Judge Graff would come back with. But here's the thing. When you look at death penalty in Utah, as well as in most states, okay, former prosecutor here, you don't get the death penalty by just proving the person's guilty of murder. In order to make that capital case stick, prosecutors have to prove at least one specific aggravating factor. So that is a circumstance under the law that takes an ordinary murder into death penalty territory. So think the murder of a child or somebody elderly, murder as connected to like a murder for hire type situation, that sort of thing. So in this case, the state is resting their entire death penalty theory on one aggravator, that Tyler Robinson, quote, knowingly created a great risk of death to someone other than Charlie Kirk. That's it. That's the only aggravator. That's the whole case. So if you knock that out, death penalty gone. Thanks for playing. So Robinson's attorneys, listen, they're not letting any grass grow under their feet. They are moving. So they filed this motion where they basically said, listen, the shooting didn't create a great risk of death to anyone else because the shooter hit the intended target. So one shot from a scoped, high-powered rifle from a rooftop.
I've never heard that argument before. That has got to be the categorically craziest argument I've ever heard. So because he hit the person, nobody else was in jeopardy. That is wild work. It's wild work. Now, mind you, I do want you to, just going to throw this out there. I don't want to leave Melba like that. I love Melba. She's a really good content creator, by the way, and a very nice person. I do want to point out something. The defense attorneys are conceding that Charlie Kirk was shot. Not an exploding microphone, not intergalactic space lasers, or any of that other retardedness that have come from the retarded conspiracy theory community. I just want to say that real quick. Just want to make sure. They're already conceding that he was shot. It just seems interesting. And they seem to be conceding that he was shot with the weapon that we're referring to. Again, not another gun, not a space laser, not somebody from the multiverse or the pocket dimension. Just something to think about. Let's go.
And they're saying the evidence shows that the bullet traveled above, not through the crowd. So no one else was in the line of fire.
Nobody else was in danger. It's crazy.
So in the messages that the prosecution has and is shared as part of discovery, there was no intent to harm anyone else other than Charlie Kirk. So
that's crazy.
The difference ends up being either A, life in prison, meaning no parole, no nothing, you leave in a pine box, that's how you leave prison, or death penalty, right? That's the big swing here, right? So prosecution, of course, is like, thanks for playing now, right? Their whole theory is that the use of the high-powered rifle over a crowd of thousands from a sniper's perch is as close to the definition of creating a great risk of death. And they also pointed to that Robinson allegedly loaded 4 rounds in case he missed the first shot. So their framework is all about the concept of line of sight or zone of danger. So if you put people within the deadly path of your weapon, you've created the risk. Whether or not you hit them is not the issue. The fact is you place them at risk. So I'm totally geeking out over this because as a former prosecutor, like this is like, whoa. Like, first off, you gotta just let this argument breathe for a second, right?
This is crazy.
The defense's whole strongest card is that, yeah, my client was accurate, so like no one else was ever in danger. I mean, that feels like, ooh, like.
But aren't they conceding? I can't understand this. To me, this is another reason why we need to whittle down the laws in this regard, because all these different flavors of murder is murder. Like all these other flavors of it, I think we need to really look at those, because we have all these different flavors and nuances. That's why they're having this argument. But the idea that he was too good of a shot, so nobody else was in danger, is crazy work. He only took one shot, one deletion. He shouldn't get aggravated murder because nobody else was in jeopardy. That's crazy. So I was wondering this question, and I know that the weapon that he was using would not have been able to do that quickly. But if he had a weapon that could have squeezed off 2 shots instantaneously, if you will, 2 shots very quickly, would this be changed? And if both of those shots hit Charlie Kirk, would it change? Because now you got 2. Because it seems like because there's one bullet, they're saying, well, that bullet hit Charlie. Nobody else was in danger. But what if another shot went off and it missed Charlie, or both of the shots hit Charlie? Like, what would have happened if it were possible in that regard? This is such an odd argument that I think is creating all these other, like, well, what if scenarios, instead of like, sir, ma'am, this is crazy work. This is crazy. So this is what they're arguing, y'all.
Yeah, that feels like off, right?
I agree.
That we're using like a John Wick argument now. But here's the thing. Feels wrong is not the legal test, right? And legally, their argument is not a bad one, right? It's not frivolous. It passes the smell test, right? Because the reality is Utah has no real case law explaining, interpreting, defining this great risk of death language. And there are only a couple decisions, and a lot of that is really focused on whether or not the defendant placed someone in that zone of danger. And the most recent time that a Utah court even got in the middle of this, the defendant had actually fired a prior shot that missed another person.
Right.
And that's very different from what we're dealing here, right?
Right.
Like, he did miss. So, thin as it may feel, the defense is standing on a very underdeveloped area of law that's like, okay. And again, that's great lawyering in terms of you exploit the parts of the law that is, basically uncharted territory and you create new law. So for me, I'm like, ooh, okay, I got to see what's going to happen here, right? And then secondly, the other critical part of this is we're still in the probable cause stage. We're nowhere near trial. And so Judge Tony Graff is not at the point of looking at whether or not Robinson is guilty or not guilty. He's going to decide at or around September 1st, two things. First, is there enough evidence to send this case to trial at all? Which I think, based on what the prosecution has presented, that's going to happen. And then secondly, whether or not this is going to be a death penalty case. And again, that is a lower bar than what the jury actually has to decide. So There's a strong chance that I think the aggravator, the death penalty, is going to stand. I think that's going to hang in there. I don't think that the defense is going to win at this juncture. But it doesn't mean that this defense basically is going to go away. So
that's such a crazy
here's
argument.
where we are. In Utah, whether the state can even ask a jury to sentence a man to death is literally going to come down to marksmanship and geometry, where a single bullet traveled and who was standing where. That's one statutory factor, one judge, one probable cause ruling that's coming at or about September 1st. And everything about whether or not this is going to be a death penalty case rides on that one day. So that's the part of the criminal justice system that never makes the headlines. So before we even get to did he do it, there's this whole quiet technical drama fight about how much the state is even allowed to seek or what they're even going to be able to present. And right here, that fight, that's the whole game right there. So stay tuned, because once we learn what happens on September 1st, trust and believe, I'll be back to let y'all know what happens next. Sound off in the comments if you have any questions on this case.
Is such a wild
in terms of the procedural stuff that we're dealing with right now and all of that. Because, again, this is my jam. I'm Melba Pearson, also known as the Resident Legal Diva. And this was The Breakdown. Stay safe, stay informed, and keep demanding justice. Take care.
In collaboration with the Midas Touch Network,
All right. Shout out to Melba. I appreciate her. She's always fun. I had never heard that argument that basically, look, nobody else was in jeopardy because my client squeezed the trigger and one projectile hit the target and it was done. That is crazy work. That is crazy. But it's interesting that they're basically conceding that he did it. So we're no longer in the I got to prove that he did it phase. We're now in the phase of, yeah, he did it, but nobody else was really in jeopardy. So he just needs life in prison, which is crazy work. I'm wondering, I believe he deserves the death penalty. But I wonder if they took the death penalty down, or if they're arguing if he get rid of the death penalty, will he just come in and say, I'm guilty, and throw me in the Gray Bar Hotel? That's what I'm wondering is going to happen. I agree. I think there's tons of people that could have been hit, but I think they're arguing is that there was only one person was hit. I don't know. I don't understand this argument. I really don't get it. I don't get it. Like, how are you making this argument? But I'm going to argue that Deb is amazing. Shout out to Deb. She said this. She said, John, thank you for the 5. John 14:27b. Let not your heart be troubled, neither let it be afraid. Good night to the best chat on the internet. Thank you so much for that. And I appreciate the encouragement. Deb, appreciate you. It's late over in Australia because you all are in the future. So it's already like Tuesday almost. Yeah. If you're in Australia, it's already in the future. So thank you so much for that. I don't understand that argument, but I would like to hear it. Maybe if Nick or Beard Lawyer or somebody else can explain it, I would love to hear. Who knows? Maybe they might prevail, and then everybody's talking about it. But I would love to hear how they square that peg. That's just a wild argument for sure. Shout out to the best live chat on the interweb. Thank you so much for tuning in to another episode of the JWhit Podcast. If you enjoyed today's show, please do me a favor and hit me up with that 3-piece special. Like the video, subscribe, and of course, share it with somebody who would also enjoy this type of content. And make sure you leave a comment because I do pin the best comments to the top. So thank you so much for tuning in today. And until next time, everybody, grace and peace.